So, for context, a couple of years before I, 21 female, was born, my dad was engaged to my mom. He had an affair with another woman, possibly fall in love with her, and got her pregnant. However, my mom forgave him. My God, she's a saint. And they got married when the child of the affair partner was like 5 months old. Yes, my dad gave him his last name. He is in the birth certificate as the father, the whole shebang. However, my dad never had any type of contact with his son, for reasons that I don't consider important for the judgment. But I will provide the info if someone wants it. My dad had cancer and passed away a month ago. He was rich, not filthy rich, but we were really well off. Like, really. My mom didn't get a dime of his inheritance because she divorced him 4 years ago, for reasons that are not related to his affair. I will provide info if someone wants it, but it's not relevant. Well, I'm his will executor, and I'm in a dilemma. Not a lot of people know he had a will prepared, and my father left everything, and I mean everything, to his bastard son. His argument was that my fiancé, 25 male, is going into the same work field, so I'm going to keep the same lifestyle as I had my entire life. That he paid for my college, true, and left a fund to pay for my wedding, and a college fund for my little brother, 17 male, to pay for his education and cover the down payment for a house, cause it's very likely that he is going to do the same, career-wise, as my dad and my fiancé. He felt that he needed to give his 3 children the same opportunities to succeed in life. I found this really unfair. He left every dollar to his oldest child. I'm talking house, some cars, a couple of million in the bank. It is a lot. We don't know this person. The only thing we have in common is our last name. I believe we don't get to pay for my father's mistakes, but my grandfather, his dad, thinks I'm being extremely selfish. He has said to me that my dad seriously neglected his son, and that this is his last chance to right his wrongs. But I still think that I am right, and that me and my brother should get at least 75% of his assets. We were his real children after all. It is very likely my dad's son doesn't even know that he passed, and probably he wouldn't care, because he didn't get to know him. So, would I be the a-hole if I don't contact my dad's son to give him his inheritance, and instead I keep it to myself and my brother? Yes, the a-hole. What's the deal with all the entitled people lately who think that just because they are executor of a will, they're allowed to do whatever they want with the money? That isn't your money to hand out. It's your father's estate money, and doing what you're thinking about doing is stealing. You can't just ignore his will. Your job is to follow the instructions. That's it. We were his real children after all. Disgusting. Yes, the a-hole. You sound entitled and greedy. Your father created a will and named his eldest son. Those were her wishes for what he wanted at the time of his death, and you are ignoring those wishes. Yes, the a-hole. He is your dad's real child, and as executor, you have a legal obligation to respect the will and file it. What you are suggesting is criminal. Not a lot of people know he had a will prepared. It only takes one to report the existence. Sounds like Grandpa knows there's a will. With millions in investments, so does his financial advisor, and the attorney who drafted the will. My father left everything, and I mean everything, to his bastard son. So challenge the will. That he paid for my college, true, and left a fund to pay for my wedding, and a college fund for my little brother, 17 male, to pay for his education, and cover the down payment for a house, cause it's very likely that he is going to do the same, career-wise. So he didn't leave everything to the other child. He left you both trust funds. He left every dollar to his oldest child. No, he didn't. You said just above you both got trust funds. We were his real children after all. So is the other son. When my brother was 16 and I was 4, my grandmother set aside a share portfolio for us. As soon as we were old enough, it was transferred into our own accounts, and it was only 4 years later that my brother dipped heavily into his and bought a new Honda. I knew about mine for much longer than he did before it became mine, and watched it grow since I understood what it was. By the time I was given full control of it, it was already worth a ridiculous amount, because a big portion of it was invested in Apple. And I'm torn on using the funds locked up as they are, because Dad drilled it into me to leave it to grow until I'm 40-something. I don't talk much with my brother. He's done some stupid things to the family over the years, and I didn't really grow up with him, so all I usually hear about his life comes through Dad. His new girlfriend works in law though, and I've received a formal letter from them both that the investments my grandmother made were designed to be for both of us to use, not just for me alone. And his was only around $15,000. The number is right, but mine was only worth that at the time he spent it too. They want half of the value of mine now, and his girlfriend has informed me that if I don't give them access, then the legal fees and fines would eat up my half, and I'd be left with nothing. The dividends alone support a huge part of my life, and they've saved me a few times. If half of that disappeared, it'd set me back years. I know it sounds selfish, but I'm really used to having the extra income back me up when I've wanted to move. I've lived in 4 states by my own choice, and I want to move and take in more before I settle down, if I ever do. How likely is it they'll win and leave me with nothing? As far as I know, there was no paperwork or will, just my grandmother's word. She set up my brother's accounts when he turned 19, but she gave them to Dad at the same time as my brother got his, and Dad transferred the whole lot to me 6 years ago. For my share, I have all the logins, the trading accounts and bank accounts are in my name, and the shares are all solely in my name too. Should I find my own lawyer, and if I need one, what kind do I need? I have an accountant I've used for years, but this doesn't seem like an accountant's problem, but a law one. Okay, I'm a California lawyer. Here's my take on it solely from your facts. Grandmother set up a trust with your dad as trustee. Father, as trustee, distributes title to both of you when you reach a certain age. The trust, the purpose of the trust your grandmother set up, is now dissolved. Once you each received control, title of your money, the trust was gone, and the purpose for which grandmother set it up, i.e., so my grandsons would have a portfolio they each could use as their own once they reached a certain age, is complete. Whatever each of you did was each your responsibility. If he had taken the money out and won the lottery, he wouldn't have raced over and given you half the proceeds, right? Lastly, you have a statute of limitations defense. If you are both in your mid-20s or older, I assume you are both in your 30s, your brother likely missed any chance to sue you for damages. Really lastly, I'm not even sure what he can sue you for. There is no longer a trust. Sleep well. He cannot take your share. They're bluffing. I work in probate, and what they're trying to do is scare you into settling, even though you don't owe him a penny. P.S. Great job keeping the portfolio. I wish I had your father's wisdom when I was a teenager. I think the older brother and his meddling girlfriend will find it impossible to get any decent lawyer to take the case on a contingency fee basis. That means would have to pay tens of thousands out of pocket in attorney's fees to pursue this, money which they probably don't have. I do believe they're bluffing, and their case has no merit. There's a reason the letter didn't come from an actual lawyer. It came from a girlfriend who works in law. By the way, who authored and/or signed the letter? You might be able to make a very plausible complaint to the State Bar of California that girlfriend is practicing law without a license, if she is involved in this. And though she may not be prosecuted for that crime, it could duck up her chances to pass the character and fitness requirements to be admitted to the bar down the road, if she ever wants to become a lawyer. Update. Mostly good news. I worked with my dad and got my own lawyer. I got the timeline of my shares wrong, but it comes out the same. What my brother and I inherited from my grandmother was originally part of my grandmother's portfolio. He was the money-savvy one. My grandmother looked after those after he died, and she personally set up my brother's accounts and gave him control of his part. She didn't do the same with mine before she died. I thought she had already set the accounts up for me and given control to Dad before passing. Instead, the shares were in her will, and she left everything she owned to my dad with instructions that what was $15,000 worth when my brother got his equivalent part would go to me when I was old enough to know how to take care of them. There was no trust. She just trusted my dad. My dad did the right thing and set up my accounts for me and gave me control 6 years ago. My dad put some of his own shares in too as an extra leg up. Dad admitted to me he'd chewed out my brother last year when he came to him asking for money, and Dad had supported him several times over the years and got to the point he'd had enough. My brother found out I still had my investments because Dad had used me as an example of how brother should have been using money. That's how my brother found out I still had shares and they'd grown. According to all that info, my lawyer tells me I'm in the clear. But it's not going to get to the point of finding that out in court, as my brother's girlfriend was only a legal secretary. I say was because the firm she worked for apologized and informed my lawyer she was terminated immediately. The letter I received from them had been edited to put her name in a position higher up than it should have been, and some of the contact information had been changed. A week after she was fired, my brother visited me begging for money. His girlfriend is in serious debt, and she took a chance on scamming cash from me and lost. I felt awful rejecting my own brother over and over, and if he hadn't involved his girlfriend needing an amount well into 5 figures, I might have given him some. The next morning I found all my tires had been slashed. Screw him, I don't feel bad anymore. The rest of the comments in the previous thread made me realize I don't know nearly enough about what I'm doing with the shares and dividends and money in general. A lot of the decisions I've made have been with Dad's help, and his advice has paid off well so far, but not because I knew it would, because I had no idea what I was doing and left it up to him. I've looked into working with a financial advisor to make the most of what I have. My grandparents died 3 years ago, and my parents were left nothing in the will. The will specifically stated they were to get land and nothing more. As for me and my sister, we were set up in a way to help avoid being taxed. I'm not entirely sure as to the method that was used, but a trust was set up with annuities and interest payments. I'm not too familiar with it, but apparently the money in the annuities are static. The interest is paid out from there, and that somehow generates less tax responsibility because the annuities are under a certain number, and if it goes higher, we get taxed more. Not entirely sure on that one. Problem is, my parents tricked us into setting up joint bank accounts with my mom as the second name on the account. We did not realize they would gain access to the money from this. We knew something was up when suddenly my parents paid off their house in a lump sum. They turned over 7 cars in a year's time, and they started living very lavishly while trying to lie to us about how impoverished they were. I have checks and a debit card for the account, but my mom keeps those locked in a safe in her room because she cannot trust me with them. While they live in luxury, we get nothing. A $50 Walmart gift card each year is it. Since the accounts were set up, we are not allowed to leave the house at all, most likely because they know we can get money out of the accounts if need be. Until this year, my parents left the money alone at tax time, so we could pay the taxes on the interest. But that's about all we have been allowed. This year, however, my parents refused to give us the debit cards to our accounts, stating that money was very tight and we would have to make do on our own. We both walked up to the Bank of America where our accounts were and got the bank info to set up a bank withdrawal for this year after our friend told us we could do that. Monday was my 18th birthday, and because my parents are literally on a cruise right now, this is what I did. I walked up to the Bank of America and lied to the banker saying the debit cards on the account were both stolen. This deactivated them. I then made a $500 withdrawal and walked across the street to the Chase building to open up a new account with the $500 I withdrew from mine. Then, using a CD, I was able to drain all but $2,000 from mine. I'm leaving just enough so they can make it back home without running out of money, hopefully. With my newfound money, I was able to walk up to the Walmart and get myself a smartphone, as I have never been allowed to own one. I had to order a taxi to take me to the office of the company that runs my inheritance. Using the banking and routing number, I was able to set up a deposit for the new account. After all of this, I was able to set up the same thing for my sister as Chase allows minor accounts at 17. Except she is not allowed to touch the inheritance account without guardian permission until she turns 18. So, I set her up with online banking and set her up with a Gmail account. We get interest payments once a month from the annuities at the exact same time, so I was able to show her how to set a bank transfer. She will just manually transfer funds, leaving just enough in the account to keep it open until she is 18. To give you an example of how much money we are talking, I bought a new car cash, and that was not even a dent. I also started renting a house and moved in today. My sister wants to move in with me, but I have a few questions about that. When they come back from the cruise, they will forbid her from living with me. So is that kidnapping? Also, is what they did illegal? The will specifically stated they were not allowed to get a dime from my grandparents. All the money was set up to flow to me and my sister. It's lawyer time for both of you. But there are other things you should do. So, the best thing you can do for your sister is hire a lawyer for her that is separate from yours. Why? Because since she is still a minor, this may fall into the realm of financial child aggression, and she may have eligibility for emancipation. According to the Texas statute, she checks all the boxes, and that will remedy her need for a guardian to govern her accounts. It's not just the inheritance, it's the fact that you two were coerced and then restricted from access to your financials while they were simultaneously living lavishly. Just because they are your parents doesn't make them entitled to that money. There may be some considerations made for paying for housing you two, but if they are on a cruise and telling you that you are poor, well, I don't think a judge is going to be too pleased on that note. Now that your parents are away and on a cruise, you are going to want to act very fast to get ahead of them before they come back and attempt to restrict her communications or movements. So, in addition to calling 2 lawyers today and getting in with them before they come back, you will need to do the following. Get copies of all important documents from you and your sister from the house. Social security cards, birth certificates, passports, and any and all banking documents related to your banking and/or your sister's. Do not take anything that isn't specifically yours or your sister's. Remove any and all items that belong specifically to you. Don't touch your parents' things, even if you believe it was purchased with your money. That can and will be mediated by your lawyer later. Once you have the documents and items, don't return to that house, not without police escort for your own safety. Go back to Bank of America and get a printout of all documents related to those accounts in both your names. She may not be able to do much with the financials at the moment without a legal guardian, but she can get all the documents. Have the bank print them out for you and stamp them with the date and time of when they were acquired. You want to have everything to include a history of transactions from the beginning of the account to now. Get your sister a secret cell phone with data and such. Make sure she hides it well and never lets the parents know it exists. Also, get her a nice compact portable charger for it. It may not be prudent for her to plug it in, but she needs to keep it charged. She may need it depending on how the parents are going to react. The piggy bank just took a walk, and she's close out the door. This is also why she needs her own lawyer. She needs protection. Your parents can't touch you, but she is still a minor. Get ahead of this. Make a plan with your sister about how to handle the parents' return. Involve the lawyer in this. Call CPS. Explain the situation. Make sure they have a heads up on what is happening. People will act rashly when they are backed into a corner. As far as if what they did was illegal, I don't know, but a lawyer will, and you need one. Well, 2, so your sister can be protected.